sort of my first official function as a member of the faculty here at SMU Dedman School of Law. So every time somebody lists off those degrees, I kind of chuckle to myself and think like, what was I thinking? But anyway, so yeah, I graduated from Duke, and then I went I'm from the Pacific Northwest originally, so I went out to Seattle to work as an associate at Perkins Coie. I was in the tech trans practice, which eventually I was a founding member of the blockchain law group, and I view myself as a blockchain lawyer to the extent that people think that that's a thing. I'm a crypto lawyer, and I was starting around 2011, before people knew what blockchain technology and cryptocurrency really were. That was the focus of my practice, that and other payments laws, until I left to teach at Stetson for 2 years in 2016. And then I spent 2 years at Michigan State, and now I'm here, which I'm extremely grateful for. So I'll teach secured transactions this fall. I'm a commercial and corporate person, so a business law person, in addition to an emerging technology person. My research focuses at the intersection of the two of those things, business law and emerging technology. And so I'll teach secured transactions and a course called Blockchain Law and Policy, which is a new offering in the curriculum this fall. That's super fun. I've taught it once before, and it's one of my favorites. And I do a lot of other things that I'm happy to tell you about, but in general, they revolve around commercial law, business law, and blockchain technology. So I sit on the UCC study committee for the Uniform Law Commission. I'm doing work with Unidrat around the same issues, many of which I'll actually talk about substantively in the discussion today. So we'll just, from there, move right in. If you have questions for me as you come back to campus, just come stop by. If I'm around, my door's open, just come on in. I like visitors. And even if you're not in my classes, please do come in for office hours. And even if you're not at the school, if you're a different school, I like interdisciplinary discussions, yeah? Okay, so the topic for today is how to negotiate and draft e-contracts. That, of course, the title begs the question, like, what is an e-contract anyway, right? And so we start there. What is an e-contract? Well, it depends on who you ask, honestly, but generally speaking, an e-contract is any kind of contract formed by the interaction of two or more individuals, surprise, it's a contract, using electronic means like email, interaction of a person with an electronic agent, so a person in a computer program, or the interaction of two electronic agents independently, so sort of autonomously forming contracts. And you're like, yeah, right, that's a thing. Well, actually, that's a thing that happens in the stock market like all the time, right? So electronic agents acting together to form contracts on the basis of instructions that people have given them prior. So although that sounds out there, it's a thing that happens regularly, and that has been happening in the securities market for quite a while. So the question, of course, once debated in the literature is it an e-contract if it's not an e-commerce, right? Are e-contracts limited only to e-commerce functions? And I tend to think no, because of sort of my expansion, sort of the area of research that I do. I think an e-contract, broadly speaking, is any contract conducted via electronic means. And I think the prior definitions that focus only on e-commerce is because that's where it came up first, right? That's where the issues started. But now you see more and more e-contracting between businesses, business to business contracting, not business to consumer. And so we'll talk about both of those contexts here in a minute. But generally speaking, there's no special law of electronic contracting, no special law of e-contracts. E-contracting is really just a method of forming agreements, just a way to form traditional contracts, the kind you learned about in first year contracts class. So for today's top discussion, I hope to proceed in two parts. I get excited, and so I might jump around a little bit, but the goal is to proceed with two general topics. First, to talk about more traditional e-contracts, like the kinds I've just described in the definition, and to talk about how the issues really in negotiating and drafting those contracts, sort of what you might think of as traditional issues. But then the second half of the discussion to focus on really emerging technology and the way that it's changing how people think about what an electronic contract is, indeed changing the actual words we use to talk about an e-contract, rather computational contracts instead of simple e-contracts. So starting with the traditional ones. What traditional issues come up when you're negotiating and drafting the contracts? And why do I put those together? Like, isn't negotiation and drafting two separate things? Like, technically, that's two separate activities, sort of. Depends on how you actually negotiate. We always negotiated straight through the draft, right? Very rarely did we get on a phone and negotiate until after you'd exchanged negotiating points in the draft itself. So for me, they were always combined. But in addition, it depends entirely on what context you are creating and interacting in your e-contracts in the first place. So we start really with the business to consumer or the B2C context. In that context, there really is no negotiating, right? You're a consumer, you're getting a cell phone, you go to AT&T and they flash you this thing that says user agreement, right? And they say scroll through it and you're like, yeah, right. And so you swipe through it and you click I accept because you want the phone, right? You don't really have a choice. So you have no negotiating power. There is no negotiating. There is drafting, right? And the fact that there is no real negotiating between the business and the consumer actually puts extra lens on the drafting issues. So it creates new, or not new, but extra issues for the drafter to keep in mind that they don't have to keep in mind in the same way when they are actively negotiating in, say, a business-to-business context. So, for example, you have to make sure you get a valid signature. And there are laws specifically that relate to that, not the least of which include case law about e-contracts, right? Some of which I'm sure was covered in contracts law. But I negotiated several cases where the clients didn't get past the do you have an enforceable contract because the checkbox wasn't right next to the hyperlink of the terms of service, right? So you have to be really careful what your user interface looks like and ensure that you have created a screen, whether it's on your mobile app or on the computer, that actually captures what will be enforceable as a valid signature. And it's been in vogue, or I should say the argument I always had with clients was, do I actually have to have the checkbox? Like, can't I just hyperlink the thing and say, I sign up? No, yes, have the checkbox and then record, like capture the data that says at 5 p.m. on August 5th, Carla checked the box, like capture that and keep it. So that when they say, I never checked the box, like, I don't know what you're talking about. Then you can say, no, actually, you did, and here's the record, right? So ensure that your user interface is built to help you prove out that you obtained a valid signature. And then ensure that your backend system records that, in fact, the user scrolled through, even if it was just a swipe, right? That's why they make you do that, because that's even better than just checking the box, right? The best is they actually had to look through it. Not my problem if they didn't read it, but we forced them to go through the terms. Then they had to check the box, and then they had to hit I confirm whatever, right? And that you record the data relating to all those things. So that's the key one. And it seems simple enough, and it's pretty well set in stone in terms of common law case law, right? But it's one that you argue with the business team all the time because they're very worried about the user interface, and aren't I going to prevent the user who wants to sign up from actually signing up if I force them to go through all those steps. And the answer back for me was maybe, but do you really want that user, right? The one that's going to try and wiggle out of it later? That's the one you want to get, But in any event, similarly and sort of connected to that is when you're drafting the business to consumer contract, do think about how you protect the draft from unconscionability attacks, right? So under state law, how do you protect whatever your state law and unconscionability is, depending on where you're offering the services and what state law you have chosen to govern the contract. Know what the law of unconscionability is there. And in fact, sometimes it's one of the reasons you pick a governing law over the other, right? Because one is more favorable than the other. For example, not California. But if you think about unconscionability as you're drafting it, you can protect the draft. That's often where the big, bold, all cap letters come in, right? Those are requirements to be like, warning, there's this specific term in here and you can't possibly claim surprise because here it is in big, bold, obvious letters. It's also why you have those, this contract contains an arbitration agreement in big, bold, huge letters in the paragraph that starts every contract that we all just skip over. Yeah, that's supposed to be, so we're not surprised when there's an arbitration agreement later on. But similarly then, carefully consider your dispute resolution clauses like arbitration agreements and class action waivers. Make sure you know the law in your jurisdiction when you do so. Make sure that if you say you're incorporating the AAA consumer rules, that you've actually gone through the process of registering your agreement with a AAA. So if you don't do that before including the arbitration agreement, AAA is not going to, or may not, they reserve the right not to, enforce the agreement themselves. Like they just might not take your arbitration. And that's worse maybe than forcing a consumer to go to state court to try and invalidate the arbitration agreement. If the arbiter themselves is like, no, you didn't follow the rules. Sorry, we're not doing this. And then lastly, and this is one I think that drafters forget sometimes, and it's always high in my mind because of the type of practice that I had. But as you're writing the contract, keep in mind your multiple audiences, right? So your immediate audience, of course, is the consumer, the one that's going to sign the document. But usually that's not your only audience. That's not the only person or entity that will be reading the contract. Well, who else might be reading the contract? Well, regulators, lawmakers, anyone interested in the underlying business activity. Oh, sorry, my light went off. Anyone interested in the underlying business activity. So for me, in the realm of payments law, the federal payments regulators and the state regulators were always secondary audiences when I'm drafting terms of service. You need to make sure that your terms of service are both consumer protection compliant, right? That you are, while also protecting your business, not defrauding, for example, consumers, but also that it makes plainly clear that you are following whatever regulatory requirements you have. So if you're not allowed to do business in certain states because, say, you don't have money transmission licenses there, then you make that clear in the terms so that when a regulator comes looking, they're like, oh yeah, see, they're clearly making an effort, at least on paper, at the surface, to comply with regulations. Even when you're not in a highly regulated context, you want to keep in mind folks like the FTC and the state level enforcers of state level consumer protection acts, right? So in other words, just keep in mind that you have multiple audiences when you are drafting business to consumer contracts, not just the consumer signing the thing, but also regulators and honestly, also competitors. So I can't underestimate the number of times that a client would come and say, hey, but my competitor so-and-so included this in their terms of service. Shouldn't I have that? Well, no, or yes, or I don't know, like you're not the same entity, you're not providing the exact same service. It makes it really hard to provide legal advice in that context because you can't analyze the competitor service, obviously. But in this regard, the other sort of multiple audience that you have is not just the consumer, not just the regulator, but also your client. So it's easy to think of your client as one entity, right? The business, but really your client's made up of the legal team who probably, if you're outside counsel, reached out to in the first place, but they have an internal client, the business folks, and the business folks and the legal team don't always agree, right? The business folks are going to be the ones worried about their user interface and how your terms of service and requirements included there or in the privacy policy affect their user interface. And they also count as an audience when you're drafting your contract, your business to consumer e-contract, right? Okay, so what about in the business to business context? Well, sometimes it's the exact same thing as the business to consumer context, because the two businesses just don't have equal bargaining power. And the result of those asymmetries is that simply the one business can take the agreement or not. And if they want the service, they just do that, right? They just take the agreement as is. On the other hand, there are contexts in which a business starts with a form document, but the other side has enough bargaining power, either because the business that they're bringing is offers such an amount of business, right? Fiscally, the bottom line is so large that the business with the form is willing to change the form, derogate from the form in certain ways in order to get the business, right? And in that case, you will do a full-on negotiation, but just starting from the form. The practical issues in that context are, one seems really simple, but it's not always. One is just know how to use track changes and the compare function in Word, right? Know how to do that and know how your client expects that you do that, because each client has a preference. Some clients want it in Google Docs, and be prepared to explain to the client why that's not a good idea for confidentiality reasons. But similarly then, know how metadata records interact with your rules of professional conduct obligations. So when you are negotiating via track changes, know what kind of metadata to strip from the document before you pass it on to the other side. Know what kind of metadata to look for when the other side sends it back, and know how both of those actions interact with your RPC obligations. Indeed, if you include metadata that reveals confidential information because you were using track changes and you weren't quite sure how the track changes created metadata that might reveal confidential information, right? That's as much as an RPC violation as if you went outside and told the details of the deal to the guy sitting next to you on the bus, right? So that one in particular, and why I emphasize knowing how track changes work, not just like how do you enter track changes, but how do you track down the audit trail that it leaves and make sure that the audit trail isn't revealing anything confidential to the other side. Is one of the key practical issues really in the B2B context. It also comes up when the other side sends back a draft. If they don't send back track changes, if they only send a clean version, how do you ensure that you're catching all of their changes so that you're protecting your client from sort of changes or negotiating points that got slipped in there? Those are very practical rather than legal. Substantive legal issues, but nevertheless, the important ones really that come up in the B2B context. And again, keep in mind your multiple audiences in both the business and legal internal audiences, but also your regulator audiences. So in my practice, for me, many of these B2B contexts were payment processing agreements, and our secondary audience was often the OCC, right? And sometimes they were even, the OCC and their regulated entities like the bank were sort of built-in third parties into the agreement mentioned, but never really with obligations. And figuring out how to best protect your client in those circumstances is really key. Because indeed, if you're in a highly regulated environment like payment processing, the OCC will be one of your audiences that you have to keep in mind and factor in to the negotiating process as much as anything else. So for both contexts now, when we're looking at substantive legal issues, it's important just to pay attention to the enabling laws, right? So in this context, unless you're in a regulated area where substantive regulation applies to the content of the transaction or the content of the contract, then there are some key enabling laws to keep in mind. And the idea of them being enabling is that they're enacted to help parties create and work through e-contracts. So the first, of course, is at the federal level, It's the Federal Electronic Signatures in Global and National Commerce Act, also known as e-Sign. So e-Sign isn't just a company, it's a federal law. It was enacted in 2000. It is essentially designed to ensure that everybody knows what rules to follow to make sure that a electronic signature is just as valid as what people refer to as a wet signature, right, with wet ink. And then similarly, UITA, or the Uniform Electronic Transactions Act, is a state uniform law designed to ensure that electronic contracting, electronic signatures in particular, are valid and enforceable signatures on a uniform basis. UITA has been adopted by 47 states. There are 3 that have their own forms of digital signature acts. I think it's New York, Washington, and Illinois, who have their own signature laws. But again, because of e-Sign sort of overlaying on top of UITA, even those derogations, those 3 derogations, are really not as different as they probably could be, because e-Sign helps mandate sort of across the board requirements for the nation. Essentially, between the 2 laws, the requirements to ensure a valid electronic signature are that the signer, so perhaps in a B2C context, the consumer, demonstrate intent to sign, that they intend to sign this thing, just like you would have to fulfill that requirement if they were signing it with a pen, right? Same requirement, nothing new. But you also must have some way to show that they've consented to doing business electronically. So you may not notice this when you sign up for your cell phone, for example, because it kind of happens fast, but it's often included as one of the provisions in the terms of service, which you probably don't read. But where it's most obvious, I think, or at least in my life, personal life, where it's been most obvious, someone sort of going through these rules step by step, has been in, say, the student loan context, or in the mortgage context, although you couldn't fully sign your mortgage online, but in the purchase and sale context, at least you first sign the I consent to do business electronically thing, right? And then you can move on to the actual document, right? So like separate disclosures and separate agreements. You have to agree first, and then you have to actually agree to the document. I'm just trying to think of what other contexts you might have encountered this in your personal life, so you can picture it in your head. But maybe the student loans one is the most obvious, because they're super careful about walking through the steps, because they don't want any way for the students to say, no, I didn't consent to this loan. I didn't consent to do business electronically. But in any event, so you have to get the signer to demonstrate that they intend to sign. You have to get them to demonstrate that they consent to do business electronically. You must show that in the context and circumstances of the signature, that there's clear signature attribution, that they are the person, in fact, who they say they are, right? So sort of validating identity, and that when I signed Carla Reyes, was actually Carla Reyes who signed it, and not like my kid, right? So you have to find a way to provide clear signature attribution. You have to find a way to show what document or what electronic record is the language in the statute, which electronic record the signature is actually intended to be associated with, right? What did she sign? Did she realize that she was in fact signing that document? And then there are related record retention requirements, both for the consumer, so enabling the consumer to retain the documents that they've signed, and then for the business, retaining evidence of consent to do business electronically, evidence of the signature, and any proof that you can create within the user interface that in fact they intended to sign that document, and that they were sort of who they say they were, right? The last sort of enabling statute that often comes, and there's one other that I don't mention here, UCITA, but it's applicable only in certain circumstances. So I didn't intend to cover that today. But the one that comes up often in this context is indeed the Uniform Commercial Code, particularly for e-commerce or e-contracts relating to the sales of goods. So Article 2. So I can't fit all of Article 2 into today's presentation. It's just enough to note that the UCC Article 2 does apply to sale of goods, whether it's an electronic sale of goods or in person, and that it's an enabling statute in order to designed to provide sort of predictability to the type of contract that happens sort of over and over and over, right? The sale of goods. So what kind of issues are emerging for traditional e-contracts, right? The terms of service types of contracts, the traditional loans via electronic means. Well, right now, at the moment, there's two that I'm most sort of pressingly aware of. Right now, sort of at the end of July, because we're in the beginning of August, right? So sort of July 20-ish, and 23rd, there's a proposal and then a bunch of lobbying letters sent to Congress about the proposal to, quote, modernize e-sign. And the proposed modernization of e-sign seems to primarily revolve around removing what's known as the reasonable demonstration requirement. It's part of the record retention requirements of e-sign. So you're required to enable the customer or enable the consumer to save, to retain documents related to the transaction. But that's only meaningful if the consumer can actually open and read the documents that you allow them to retain, right? So the reasonable demonstration requirement in e-sign is essentially that you provide a way to reasonably demonstrate that the consumer can receive and read the document in whatever form you're going to send them, right? So if you send, for example, the loans, your student loans are sent to you in a PDF afterwards, like the copy of what you signed is sent to you in a PDF afterwards, the loan provider is required to attempt to reasonably demonstrate before asking you to sign, before completing the transaction, that you can in fact open PDFs and read them. And so, and maybe this just reveals how old I am, but when I signed for my student loans, right, and I remember distinctly because it was just a rather large pain to go through the process, but they'd send you one PDF, right? You download a PDF and you'd open it and have just a code inside. And then you were required to take the validation code and put it into the system to show that you could in fact read what was inside the PDF, and then you'd be allowed to move on. Similarly, they might send you an email if that's how they're going to deliver the documents, but the idea is to get you to prove that you have the technology that makes you capable of reading the records that they're required to provide you relating to your transaction. The argument for eliminating the reasonable demonstration requirement is that it's cumbersome, and that's no joke, right? So it's cumbersome from the consumer perspective, but it's also cumbersome from the business's perspective. Particularly think about businesses whose plan is to send you an email receipt, right? Maybe a receipt is all that, because it's not a loan, so there's not all these really detailed documents, but maybe a receipt for the sale of goods is all that they're planning to send you after the fact. But they're required to send you a copy of your authorization for payment. So how do they prove that you can receive and open an email? So maybe the validation code thing, right? That happens frequently enough. But what about bounce rate? What about, it went to your spam folder. How do e-commerce companies really implement a system that reasonably demonstrates or fulfills the reasonable demonstration requirement without just a ton of expense? The other reason it's cumbersome is because there are like a ton of federal laws that you wouldn't expect to incorporate e-sign, but that do in fact incorporate e-sign, and as a result incorporate the reasonable demonstration requirement. For example, Reg E. Reg E is for banks and payment providers, requires certain disclosures. But then essentially by incorporating e-sign, what you've said is you have to prove every time you send like 6 disclosures. So you have to send 6 disclosures in order to provide the required disclosure. And then, and at each stage, you have to provide and fulfill the reasonable demonstration requirement. It just becomes quite cumbersome. It's also just not clear whether traditionally under e-sign, a disclosure would count as something that's required, but it's incorporated into Reg E, so it's just not clear. It just seemed to have been fashionable to just incorporate e-sign into certain federal, other federal laws. And that makes it quite cumbersome, right? On the back end, doing the legal analysis to figure out if you have to comply with the reasonable demonstration requirement at all. So it's been an argument for quite a long time that the reasonable demonstration requirement should be removed, that it's a holdover from, the early era of the internet. I don't know about that so much, but that, at the very least, it does continue, sort of act as a continued demonstration of federal preference for paper contracting over electronic contracting, and that in today's age, that's just not helpful. And it's sort of seen as a push towards modernizing contracting generally, and federal law's preference, modernizing their preference for paper over electronic things, more broadly speaking. But the reason it's come up now, or why there's like a renewed push for it, is because of the pandemic, right? So because of the pandemic, traditional sectors that rely on paper or even preference paper have had to figure out creative ways to fulfill their requirements, right? So during the pandemic, I have sold and purchased a home. Closings were very different than what I've experienced in the past, because you can't be in person, right? You're all supposed to sit around the table and sign and exchange the keys. You can't do that. So depending on where you live, county by county, maybe you can do a digital closing, maybe you can't, right? Depends on the real property laws. But even when you could do a digital closing, many of the lending documents required wet signatures. And so because of federal law. And so the argument was, look, you're restricting banking services, electronic banking services, in a time where it's really impossible to comply with the paper in-person requirements. And even where it's not impossible, where it's just like super cumbersome now. And that spills over to things like converting from paper banking services to electronic ones, et cetera. To leases, right? Forget buying the house, but if you need to sign the lease, can you do that electronically? And the argument is certainly that there are people who need access to electronic contracting who are prevented from that because the business can't figure out how to comply with the reasonable demonstration requirement in a quick time, in an efficient time, in a cost-efficient time, in a cost-efficient way. And so it sort of renewed the push for getting rid of it. The counter argument, of course, is, look, the reasonable demonstration requirement provides an important consumer protection function, right? We're making sure that the consumer you're selling stuff to can actually read the terms on which you're selling, you're conducting the transaction, right? And particularly in financial services around loans, like you want to make sure the consumer can read what interest you're charging them, right? We have these disclosure requirements for a reason. And particularly like those, if in fact serves those important consumer protection functions, then those concerns are only heightened during a pandemic, not lessened. Right? We don't want to allow sort of unscrupulous behavior, sort of poaching on people when they're already struggling. And so that's sort of the continued debate right now around e-sign. I will say, though, that sort of industry and from whom I've talked to so far, most folks are in favor of removing the reasonable demonstration requirement from industry anyway. The consumer protection people have not weighed in yet. I think they're struggling between a real recognition that there's a need to access digital services in the pandemic versus like, but how do we still continue to protect consumers in an appropriate way given the circumstances? The other sort of emerging issue at present is around the UCC. So I sit on the Uniform Law Commission's UCC study committee for, what is it? I actually don't know the name. I think it's called the Study Committee for the Uniform Commercial Code and Emerging Technology. And what we're working to do is sort of go through the whole of the UCC and think about where it might need to be updated or modernized, like eSign, to account for emerging technology. Things like blockchain technology, smart contracts, and things not quite so emerging like remote deposit, right? Like updates to the NACHA system. So the idea of electronic negotiable instruments, can you have, like, is that a thing that you can really have rather than just remote deposit of a paper negotiable instrument? And we are just now a year into the study committee, and we are making progress. I think most of the discussion to date has been around digital assets, including new classes of digital assets and how people contract for those, and what industry practices. So the UCC has a long history of both being technology neutral. Any changes to the UCC should be technology neutral, and they strive very hard to make law that applies to things people are actually doing, right? So they don't really believe in making law for future states of the world that they can't predict, which I strongly admire. And so we've been doing a lot of sort of research, just what are people doing? Are people doing anything? Or is this like all in the hype cycle in the news, but nobody's actually using electronic negotiable instruments, for example. So that's another area of emerging issues in this regard, because the UCC would apply to any, right, e-contracts around the sale of goods, but also any, you could imagine secured loan on a digital asset. If you're taking secured loan on a digital asset, absent any e-sign requirements or other banking requirements, you might imagine that those folks would do so via e-contracts, right? If the asset itself is something that lives natively in the ether, then it would, wisdom would serve that they're going to contract electronically as well. So it would intersect e-contracts in that way. And then lastly, there have been a variety of individual states amending the Uniform Electronics Transaction Act to, quote, accommodate smart contracts. And I'm not going to talk about that much here. If you're interested in what they're doing, I have a list, or I have resources that list each change, like in a chart. You can go through it and see it, but they're terrible, right? My personal assessment is that they're terrible. UITA does not need to be amended to accommodate smart contracts. Smart contracts are already included in the definitions of UITA, which are technology neutral and quite broad. And most of the amendments at the state level so far have done the exact opposite of what they intend to do. Rather than accommodate them to make sure that smart contracts are included, they've actually managed to exclude most of smart contracts because they've described the technology improperly. So they'll define smart contract or they'll define blockchain technology, but they'll use a definition that doesn't make any sense, such that they've defined technology that does not actually exist in real life, right? The exact opposite of what the Uniform Law Commission did in the original text of UITA. And so really the state amendments to UITA are quite the problem. And I might expect to see the Uniform Law Commission take up their own recommended amendments to UITA, maybe in order to really address the corresponding issues from the UCC committee, but then also just to comment at least on the ridiculousness of some of the smart contract amendments to UITA. So now you're sitting there thinking, okay, what, if you haven't heard the term before, what is a smart contract, right? So we started with what is an e-contract, and now you've got the question, what is a smart contract? And that leads us to the second portion of today's discussion. I said I'd proceed in two parts. The first was the traditional issues, and now the emerging issues. And this is the stuff where I really focus my research.
Carla, I was just thinking maybe we could stop to see if there's any specific questions.
Yeah.
On the first part. You can put your questions in the chat box if you like. Okay, well, if people have questions, you can add them, and then, oh, Floy has a question. I've seen some pushback with click
Yeah.
wrap agreements in court. How has drafting changed in response to that litigation? Good question.
Yeah, it's a good question. And most of it relates to the user interface and how you capture assent and convincing the business to, in fact, require folks to read through the terms. You'll see a lot more of that. I think just as time goes by, I've seen a lot more of that. But yeah, but most of it relates to making sure you give the consumer the opportunity to read the terms and actually meaningfully agree to them. The other part revolves around the unconscionability analysis, right? Did they know what was in there? Even if you did give them time to read it, did they really understand what you put in there? And some of that is around our consumer arbitration clauses and class action waivers. Quite a bit of it for a long while was actually. But to be honest, drafting the contracts themselves has not changed much. Most of the objection is to the idea of a contract of adhesion, right? One that a consumer can't negotiate. The problem is, in the world of e-commerce, that's all that exists, right? Like it's not feasible for say Amazon to negotiate with you, to allow you to negotiate at the moment anyway, every sale of a good via their platform. And so for now, what we have is what we have. And the best you can do is trying to protect the draft from, and the user interface from accusations that the consumer didn't actually agree or that they didn't know what the content of the draft included. That's a good question. And I'd say certain states are tougher than others, right? So California and Illinois in particular are places to carefully draft the contract with an eye towards litigation development. Yeah.
See if you agree with this characterization. Seems like in the e-commerce situation, it's even more so based on form over substance. Maybe that's why, because of the user interface. Is that correct? Or is that sort of just how contracts are in general?
Well, there's always an emphasis placed on the form of the contract, right? And particularly around documenting assent of both parties, and particularly where the parties have unequal bargaining power. So in consumer protection contexts. But yeah, I mean, for the user interface, like for I guess if I understand the question correctly, definitely the way that you present the contract to the consumer is as important as what the contract actually says.
Well,
right?
and maybe what I'm saying here though is, other than putting things in all caps in a written contract, I don't see that there's a whole lot of focus really on how it's presented truly, right? Whereas in the e-commerce environment, it seems like there's more attention paid to the appearance.
Yeah, if for the lawyer, there should be anyway. And then the question is whether you can convince the business to do that within the user interface, right? So, and in particular, maybe in the mobile app context, right? So easy answers in the mobile app context is to always include have a place in the app where you can go to like legal and have a hyperlink to the current version of the terms, right? Some app developers make the mistake of loading a static version of the terms to the app and including it there, and such that they'd have to redo it every single time. So then they just don't redo it, which is a terrible idea, right? You want to link to a dynamic version of the terms. So you can update as necessary. But really, the onus is on outside counsel usually, sometimes in-house counsel. But it's harder for them to push for things like that, though. But usually, an outside counsel to push hard and to sort of play the bad guy on behalf of in-house counsel, so that they don't have to be the bad guy, to get the business to focus on those things, which is not what they want to focus on in their user interface. That's not the kind of thing they're excited about, right?
Yeah. Right. I can speak from my own experience, but that assumes, number one, there is in-house counsel, right? And number two, that they were consulted. So, I think probably in startups or early stage companies, which many companies might be when they're doing e-commerce or app-based ventures, it's a little challenging, and maybe they don't go to outside counsel either, but I'm sure.
So I think it depends on what what industry the startup's in. So in my practice area, most startups who got investors, who actually had angel investors or otherwise, that they were required to seek outside counsel for their terms of service and privacy policy. That's stuff that the investors just didn't mess around with. And it was expected as part of the investment that they do so. So I think it depends on the industry and the particular situation of the startup company. But sure, they may not have in-house counsel at the outset.
That's great advice. Any other questions before we move to the next portion? Great, thank you.
Okay, so this is where I think the cool stuff is, frankly. We move sort of from this idea of an e-contract, an electronic contract, just a contract that you do via email or a form or something, to something called, more broadly called computational contracts, right? The idea is that the contract itself is code. In some way, shape, or form. And the idea of computational contracting can involve a variety of types of technology. So the earliest literature around it and sort of the earliest examples of it are algorithmic contracts. So again, to this securities example of, it happened again, sorry, of the trading, high frequency trading, where the algorithms interact with each other. That's computational contracting, where you set an algorithm per the terms of what you're willing to buy or sell for, and then you let the algorithm do the actual contracting with another algorithm. All right, that's a very common example of computational contract. More recently, there's been lots of talk around something called a smart contract, this thing that all the states are changing UIDA to accommodate. What is a smart contract? If you've never heard the term before, well, very broadly speaking, a smart contract is simply very simple. It can be a very simple computer program that just says, if X happens, then Y will result, right? So if X happens, then the computer program will execute Y. So technically, even the very sophisticated trading algorithms could be considered a smart contract. If the price hits X, then sell, right? If X, then Y. But more frequently, you hear the term smart contract associated with people thinking specifically of smart contracts running on top of blockchain technology. So if you don't know, or if you're not familiar with the term blockchain technology, which I've used several times at this point, blockchain technology is distributed software run by a peer network of computers that seeks to get the computers to agree on the existence and evolution of shared facts between them. So imagine a ledger of transactions. There is no one entity keeping the ledger, right? There's no me keeping an Excel spreadsheet, for example. There's no bank keeping a ledger of a bank account. Rather, it's a distributed network of computers using distributed software to collectively agree on the state of the ledger of transactions. That's distributed ledger technology, more broadly speaking, but specifically when people say blockchain technology, they mean one type of distributed ledger that uses a particular type of technology that links the records forming the ledger via cryptographic blocks, right? So it's literally a chain of blocks that makes something a blockchain technology rather than just a distributed ledger. A smart contract in blockchain land is if X, then Y, that runs on top of the ledger, right? So the ledger runs on top of the internet, right? So you have the internet, you run blockchain technology on top of the internet. The blockchain technology is itself a type of protocol, just like the internet is a protocol. And so you can run other programs on top of blockchain, just like you can run web pages on top of the internet, right? So you run blockchain on top of the internet. It's just an application that runs on top of the internet. You can run other things on top of blockchain. And smart contracts are often those things. And it's just a computer program that runs on top of the ledger that says, if X happens, then make the ledger record Y. There's been a lot of confusion among legal folks because of the term smart contract. There's some thought that maybe it is an artificially intelligent version of offer acceptance and mutual consideration, right? It is not. The catchphrase that I don't fully love, but the catchphrase that people use is a smart contract is neither smart nor a contract. And what they mean by that is it's not artificially intelligent, right? It's just a little computer program that says if X then Y. It's not machine learning. It's not a neural network. It's none of that. It's just a simple computer program. And it's not necessarily a contract. It's not, it is not required to have mutually agreed exchange of consideration with mutual assent and offer acceptance and all of that, right? To be a smart contract, you don't have to have that. It can be, however, which is why I don't love the phrase it's neither smart nor a contract, because it could. A smart contract could incorporate or reach out to artificial intelligence to have data fed to it. And it could be a contract or it could be part of a contract. But at the very base, that is not the technical definition of smart contract. So when we talk about computational contracts, there's been a tendency in legal circles in particular, and for technologists talking to lawyers more broadly, to refer to programmable legal contracts when they mean using a smart contract to create a legally enforceable contract, when they mean using a smart contract to actually create a offer acceptance, mutual consideration type contract, right? So programmable legal contracts are computational contracts, so contracts in computer code that use smart contracts as the computer code that are intended to be a legally enforceable contract, one that you could enforce in court if you could get the court to understand the code, of course. That's a whole nother set of issues. But there are a variety of industry groups working to develop legally enforceable or programmable legal contracts products, and those products vary in their sort of type or technology on the back end. So you've got Legal Pros templates, which come from the banks, really, Barclay and Corda, and that is reflective of their clients, right? So Corda is a consortium of banks that created, well, R3 is a consortia of banks that created Corda, which is their distributed ledger. And the types of contracts that they want to accomplish on the distributed ledger via smart contracting technology requires disclosures under federal laws like Reg E. So they need the smart contract to interact with legal text, legal prose, right? Written words. And so Barclay and Corda solutions for programmable legal contracts are often a mix of legal prose as a template with either connected to, like side by side, the code that is allegedly implements the words, or with like code snippets stuck into the words, right? So there's a bunch of words and says, if you do this, then you get paid, 10 ether or whatever, 10 cryptocurrency, right? Or $10, but then you exchange it in the back end using cryptocurrency. And that piece about then you get paid, that might be a smart contract, right? But the rest of it is just regular words that you would use in a contract. Ricardian contracts are like from open law, and similarly prose as objects, it's just common accord, is just another way of doing a Ricardian contract, are where you set the words and the code side by side, and open law or common accord tells you, yeah, this is the same thing. You wrote this and we implemented, we wrote code that does what you said. The difficulty there, of course, you just have to trust open law and common accord that they actually coded what the words say, unless of course you can code, but most lawyers can't, right? At least, and even if they can, most lawyers don't code in Solidity, the language of Ethereum, for example, where these smart contracts are mostly written. And then of course you can just use smart contracts without any of the other fancy stuff, legal prose, recording contracts, all that. You could just try and use smart contract code to create a legal contract, and it's possible, maybe more difficult, but possible. And so there are several platforms you can do that in, but most commonly you're going to do that in Ethereum, which is a cryptocurrency platform. Probably, if you've heard of them, Bitcoin is the most prominent one you've heard of, and Ethereum is maybe second most common. Bitcoin does not support as many smart contract applications as Ethereum does. It's just not, it's harder in the code to achieve things. So usually when people are talking about blockchain-based smart contracts, they think Ethereum or maybe EOS. So why, if this is so cool, why aren't people using them? Well, so smart contracts aren't always contracts. To make like an actual legal contract out of a smart contract, it requires a bit of a mental model shift. You have to think about what a contract is and what you're trying to achieve with it differently. So one of the projects that I work on with Unijurat is, which if you're not familiar, is a independent IGO that works on standardization of private law, sort of on an international scale. One of the projects I've just been invited to contribute to is looking at how you enforce, like what does enforcement look like in the context of the digital era. So if you have a smart contract, for example, what does enforcement look like in the context of a smart contract gone wrong? And the reality is a smart contract doesn't require enforcement. So you'll hear people talk about smart contracts as though they are self-executing or self-enforcing. That's the tagline if you Google smart contracts that you'll get. Smart contracts are self-enforcing contracts. No, they are not. So smart contracts are set up so that they incentivize performance, not automate enforcement, right? So if you think of what a smart contract is, if X happens, then Y, you might think of like an escrow agreement. Say my nephew promises to mow my lawn. I say, dear nephew, if you mow my lawn, I will pay you. How much does a lawn mowing go for these days? I don't know, I usually mow it myself, but if you mow my lawn, I will pay you $50, right? Make it worth your time in the heat. It's not a very big lawn. And so I will do this via smart contract. So the way it would work is I would stake, what they call stake, the $50. I would put the $50 up and I'd tie it up in a smart contract and I'd say, here's my $50, smart contract code, hold it for me unless and until he's completed the lawn mowing, right? And once the lawn mowing has happened, so he agrees to it, he says, yes, I will do this. Once it has happened, then the funds are released to him. Sounds like a unilateral contract. So it's not if there's actually an agreement. So I stand with my nephew and I say, I will pay you $50 if you mow my lawn. And that's an offer. And he says, yes, I will mow your lawn for $50. And that's an acceptance. And you mutually agree and you shake hands and you say, the method by which we will perform this is via smart contract. You will. So all I've done is automate the payment performance, right? So instead of writing him a check to perform my payment obligation, I've written a smart contract. The difference then is when it comes to if he never, if I write the check in advance and I give it to him and he never mows the lawn, he can still cash a check, right? Under commercial law, I wrote it and I dated it. That's my problem, right? The difference here is if, so then he could, to solve that, we say you can have the check after you mow the lawn. I'm not gonna pay you till after you mow the lawn. He says, what? So I know you're having financial difficulty, Aunt Carla. I'm not doing that. Pay up front because I need to know you got the $50. Right. So and this, now we're getting into a little bit of like stretch your imagination here because $50 mowing a lawn, but that's really what you're counterbalancing, right? On the person performing the services side, does the person really have the funds? So versus if I give the funds in advance, how do I ensure that the person performs the service? Well, in smart contract payment land, I can tie up the money, prove I have it, and then wait until he performs or not. And if he doesn't perform, then I get the money is released back to me. I'm not out it, right? I'm out the time value of money that it's been tied up there, right? But the money is just sitting there. He doesn't actually have it. He can't spend it. And if he doesn't do it, then I get it back. So what I've done is if you want the money, you have to perform. So I am incentivizing performance, his performance of mowing the lawn. And similarly, he is incentivizing my performance because I staked the money, right? So the mental shift, right, isn't that I'll pay you and if you don't perform, then I sue you to get it back, right? Or he performs, but I never pay, so now he has to sue me and force the contract to get the $50. Rather, the emphasis is on incentivizing both parties to perform, but providing technological methods to ensure that each party is protected in that performance. So not self-enforcing, but rather a method for incentivizing performance of a contract. Note there that in that example, the smart contract itself wasn't the contract. The contract was the larger agreement to mow the lawn for $50. And the smart contract was the performance piece. Typically speaking, that's what we're seeing in industry. To the extent people are using smart contracts in commercial contracts, they're using it as one small piece of an actual larger document. Often at this point, the payments piece. So there was a big project with a procurement contract. Who was it? It was a big org. It was maybe I think it was org, and they had a procurement contract that they automated for one of their clients, where what they really automated was just like the schedule in the back that was, if you know, the very standard terms on which you provide the goods, you get paid on these very standardized terms. We're just going to automate that to both incentivize continued performance, but also to reduce transaction costs for both parties. So typically where you're seeing this is long-term contracts where the parties know each other very well and expect performance to continue as it always has, but they're trying to decrease transaction costs and save money in some way. So they automate performance, usually of, so far, the payments requirements. But it doesn't need to stop there. If lawyers can sort of shift this mental model from thinking about a contract as something that creates legal rights that can then be enforced when things go wrong, to something that creates legal rights, but then also just incentivizes performance of those rights and protects the parties in the performance of those rights, then we might find ways to create programmable legal contracts using smart contracts themselves. But that mental model shift is in itself a barrier to using smart contracts in that way. The second barrier is a practical one, right? Lawyers are often not also coders, and to the extent they are, very few of them work in Solidity or Eternity, the languages of the platforms that use or enable smart contracting in this way. So really what's missing is an easy way for lawyers and law professors to code smart contracts. I would admit I myself cannot code in an Ethereum or Eternity, right? Then the theoretical issue that people love to talk about is jurisdiction. I don't worry about jurisdiction so much. Like, that's an issue that we have solved for e-commerce, for example, and it's an issue that could be solved similarly for smart contracts. That are in fact legal contracts. It's just going to take a little bit of ingenuity, but the same exact, like international shoe principles would apply, right? It's not a new issue. We solved it for most of e-commerce. We can figure it out for this too, but it is one that people love to talk about. And maybe the wrinkle here, or what people say is the wrinkle, is that technically the contract is being performed all over the world, right? So if the payments performance is via smart contract, those smart contracts are performed literally by that network of distributed network of computers that can literally be located anywhere in the world. And so, like, what does it mean to have a performance of a contract where the performance is accomplished literally across the world all at the same time, right? That's the wrinkle, arguably. But technically, that's the same thing that people said back with the internet. And that's not how the law worked out, right? So I have faith that we could figure this one out too. This one the jurisdiction doesn't bother me, but I include it here because it is an talked about issue. So, so you're like, all right, so if smart contracts are cool, but you can't really use them, what's so cool about them? Well, here's the thing. Pretty soon we will be able to use them. In fact, I can use them now because the way you write them is changing. So a quick look at what I mean when I say, like, lawyers aren't going to want to write the code. Here is maybe the very most simple, the code for the most simple possible smart contract on the Bitcoin blockchain, which is really just a multi-sig transaction. But it's all of this code that you see here. So this is the most simple and for most coders in the space, quite simple smart contract. But if you wanted to do similarly a very simple smart contract in Ethereum, it's all of this, right? And this is just to create a token, a very simple token, not transfer it anywhere, not build it in as an automatic payment part of a contract, not even build it in as a single part of a bigger contract. Is just to create a token. That's all I've done, all of that, right? I'm looking at that, I'm thinking I'm not doing that. You're not gonna make me touch that with a 10-foot pole. But folks are innovating, continuing to innovate around computational contracting, believing that eventually being able to use computational contracts widely will in fact reduce transaction costs. And sort of enable additional avenues of commerce, and frankly, enable, and this is part of what I research on the business entity side, but enable new avenues, sort of new forms of commerce, new, more equitable forms, potentially, not by default, but people are experimenting with, say, workers' cooperatives run entirely through code, right? Ways to reduce transaction costs in ways that enable folks to take an alternative approach to wealth accumulation rather than the traditional corporation. But to do that, like, that's a lot of code. So how can we enable more broadly folks to interact with smart contracts? Well, it would be great if you could write a smart contract in English, right? And so this is a smart contract written in English. It is sort of primitive to the extent that it is a contract for an escrow agreement. But Lexon is a natural language programming language designed to enable us, anyone, to write smart contracts in English. The words you see there, although written in Word and copied and pasted onto this slide, it is executable computer code. Right, those words are code that a computer could read and implement as a smart contract on Ethereum and on Eternity. So far, it is. I mean, yeah. So far, it is usable on those two platforms. Now, again, if you read this and you're familiar with escrow agreements, you look at it and you think, that's not quite what the escrow agreement I would write would look like. Yes. Clearly, but that's not the point. The point is you can write it in English, and it's really cool, right? Okay, so it will get more sophisticated as it goes, as the language grows. But this would work. It's not elegant, but it would work. It would be both a legally enforceable contract from a written language perspective that a judge could read, but also it's code that would just execute. So you don't have to trust open law or Common Accord to take what you've written in Word and translate it into code. You wrote the words that are the code. Yeah. So like I said, I don't code. Yeah. I researched this stuff as a former lawyer in the area. I do have learned quite a bit about the technology, but I have not learned to code it. So I had this project that I've worked on for quite a while, in which I argue that, and for those of you who've taken secure transactions or who will, you'll know what I'm talking about eventually. But they're in secure transaction, when someone takes out a loan, the lender files a financing statement, usually, to perfect the collateral and to claim priority, right? To claim their place in line in case the person can't pay back the loan and the collateral is seized, or if they go into bankruptcy, right? So that they get paid first. And the UCC1 financing statement doesn't work super well because still you have often the financing offices require that you fill out a PDF by hand and turn it in person. Maybe if you're lucky, you can fill it out on the computer, print it out, and turn it in person. If you're really lucky, there are a couple of jurisdictions where you can file digitally, which is great, but you're still filling out essentially a PDF, like a fancy PDF, and filing online. So I have long argued, I think of it, it's a long time for me, but since around 2017, argued that we could modernize the filing system using blockchain technology. And I was challenged via Twitter, no joke, to build it. They said, that's a great idea, but can you build it? Prove it. And at the time, the answer was, I can't code, right? I can ask somebody else to build it, but I can't do it. And then along comes Lexon, who is which is led by a good friend of mine, Henning Diedrich, out of Berlin. And I read his paper and I'm like, wait, I think I can do this, right? So I sit down and read. He's sort of over the years expanded his documentation, and eventually he gets to a place where I read a chapter of a book that he's written, and I'm like, I think I can do this. So I sit down, and in the course of 2 hours, I code a UCC1 financing statement. I didn't get it quite right, but I tried. And I took it to him and said, hey, this is what I came up with. What do you think? He said, you're close, but here's where the problem, like, this is where this won't work. And that discussion, the dialogue, is where, is like literally where I had to shift my mental model of what I understood the requirements of the form from the code, from the Uniform Commercial Code to be, to how could I replicate that in the context of blockchain code, in the context of smart contracts, right? What's the functional equivalence, right? So it required me to think about what is the function of the law, what is it attempting to achieve functionally, and how do I replicate that in code? And so again, sort of this is, I get excited and I talk and I don't go through, I don't go through the PowerPoints, but why, just backing up a bit, why the argument that the UCC financing statement is a good thing to code in smart contracts? Well, because it's built on blockchain technology, right? But why blockchain technology for the financing system? Because the whole point of the financing system is for the lender to put every other lender on notice that that is my collateral. And if you loan against it in the future, that's your problem, but I'm first, right? So it's a notice system. But because we file in paper and there's paper lags and paper gets destroyed and the filing office does things wrong. Sorry if you're a filing office person. I often offend them when I say that. Then it doesn't work the way that it's intended. So the argument goes, distributed ledger technology is designed to give everybody notice about the existence and evolution of shared facts between them, things that you all want to know about the other person, but you don't trust it, like the banks don't trust each other, right? But you do want to know what order you're in line for the collateral. So how do we create a notice system that really works? Well, that's what blockchain is for, right? That's how I got to this use of smart contracts in the first place. And the goal, of course, as even with the functional approach and the mental model shift, is to try and create something that could be used right now without any legal change, because it takes forever to change the UCC. As I've said, the study committee is in its first year of work. After the study committee finishes that work, year 2, year 3, it has to go to a drafting committee, which will equally spend 2 or 3 years, right? And then it has to get approved, both by the ULC and the ALI, 2 groups that work to create the drafts, but then later the states themselves have to adopt it, right? So it's just gonna take forever to adopt it. So with that in mind, I want something you could adopt right now if you're a filing statement, if you're a filing office, without any change to the law, and still comply with the existing code requirements for the form, and yet modernize your system. And so here's that PDF form I mentioned. It's been that way for who knows how long. And here's the version in Lexon, right? It's literally words that defines the exact same fields as the form. And when entered in the computer, right, you build a nice user interface on top so that so this is the backend code. All the user would see is a fillable text box that says, what is the debtor's name? What is the filer's name? All the stuff they're used to seeing in the PDF form. In fact, if you wanted to, you could create a user interface that looks like the ugly PDF form, right? So people are used to what they're filling out, but really is just an interactive user face that fills out the fields of the smart contract. But the point here is I coded this in English. And to the extent that Lexon becomes more robust and can be used more widely, right? This will change the nature of smart contracting and computational contracting more broadly. And we'll see sort of, I mean, my hope is, because I think this is really cool, my hope would be that we could see some shifting from maybe particularly in business to business context, from e-contracting to at least parts of contracts in computational form, right? Still in words, but the words themselves being a computational contract. And it could just be the one schedule at the end, like in the procurement example. It could be just the payments terms at the end, or maybe it's your SLA, your service level agreements, which are measurements of technological facts anyway. Maybe you can automatically measure them and record them via computational contracting, via smart contracts. But to the extent that you could, like if somebody could figure out how to automate an SLA, that would save business to business contracting parties tons of money over the life of the contract for monitoring and evaluating the service levels, right? So there's lots of super cool applications with this, not the least of which I think is the UCC1 filing form, but then of course I'm biased. But it's just, I think I have to say this thing that I'm working on here is like one of my favorite projects right now. It's just super fun. And I'm working on now coding a couple of other simple agreements related to other research around corporations and LLCs. But yeah, so this is where computational contracting is going. And the reason that it's important to know about it is because when people say things like computational contracts and programmable legal contracts, it's important not to dismiss them quite so quickly as like this futuristic Skynet thing that's going to happen right in the Terminator movie, but actually like it's coming, and it's coming in a way that can be used widely by people who don't even know how to code, right? So implications beyond just that, right, which is a big one. Generally speaking, it means that you can create what I call crypto legal structures. So it invites the opportunity to regulate also using smart contracts. So think of all the times I mentioned in the first half of the program that you have to be careful in the contract to placate the regulators, right? To follow your regulatory requirements and evidence that you're doing so in the contract. Well, imagine if you could automate that compliance right in the contract so that when the regulators came, you're like, yeah, here it is. Here's the evidence that I complied real time, and here's the audit trail. There you go. Not only would you save yourself money from the audit process, but we'd save the government money from the audit process, right? There might be some auditors who would not be happy about, right, their hours being reduced, but in any event, it's conceivable that not only, and I think the UCC1 filing statement is an example of that, right? It's on the line between, this is not really a law, right? It's a form that you file in order to have certain legal rights attributed to you, right? Priority and perfection. But it's still just a form. So it's right at the intersection of coding law, but also coding contracts. And I think there are a number of other places where you can think about where those two things meet, right? Where you could use computational contracts to actually create what's known as RegTech, right? Regulatory technology, technology that helps people comply with their regulatory obligations as much as their contractual performance obligations. I do think the other implication is that now it's possible for lawyers and law professors to create computational contracts, even if they don't have a coding background, but that doing so will require a slightly different mental model, and you got to think through it a little bit differently, which I think will have sort of carry back implications for the traditional types of e-contracts, right? Where when we're talking about, does the content of the contract change? Well, maybe in light of new and emerging technology and the way people think about contracting more broadly. What I note from my own experience doing it is that rather than, so when I say this to practicing lawyers that it's going to require a mental model shift, they're like, oh, we don't want to do that, right? We've been practicing and drafting contracts the way we've been doing it for however long, and it's perfect, right? We made a lot of money that way. We don't need to change anything. I'm not doing it. But when I went through the exercise, it actually made the draft of the form better, rather than, right, detract from the end product. And I think that's true, or could be true, for traditional contracting, e-contracting as well, that rethinking some of these things like the e-sign reasonable demonstration requirement can result in a better product, a better contract, than rather than making a worse one, which is usually sort of the intuitive response that you get. Oh, I've been doing it this way for hundreds of years, right? Or our firm has done it this way for hundreds of years. I don't have to change. Maybe, but maybe changing could be useful. And then, like I said, this is just super fun. That's my big implication is that maybe it makes contracting fun again, to the extent that drafting has become less than fun for some practitioners. That's the talk.
I
So
think
I would,
that's the best news, right? Is making contracts fun again. We should do hats on that or something, right?
yeah.
That's perfect.
So I would welcome questions if you have them.
So if you would put those in the chat box, that would be great. We have about 5 more minutes, and glad to take any questions. Also, you can see there Professor Reyes' email address, so I'm sure she'd be glad to answer any questions if you want to reach out to her directly. And as she mentioned, she's here in her office during her office hours on the second floor of Story Hall. Well, while we're waiting for any final, oh, here's a question from Kelly Neal. So, do you see any resistance to quote smart contracts and the like, as they could eventually take away profits and eventually jobs from attorneys? We wouldn't want to do that.
Yeah. You see people resistant on using those objections, but the reality is like that I don't see that happening, right? So there is this deeper industry, and by industry I mean legal industry debate about, do we need to know how to code to stay relevant? Should we be legal engineers, right? And I don't think that debate is quite on point. There will always be a role for lawyers, right? And which is why I think for adoption of smart contracts as computational contracts, like as programmable legal contracts, things like Lexon and other initiatives like Lexon are so important, because the folks I know are not just going to trust the coders. Like they're not just going to give you a contract and be like, hey, coder, code that, and then just trust that it's the same. In fact, they can't under the RPCs, right? You have to be able to advise your client what they're signing. If you can't read the code and be sure that it's the same, I don't know how you do that, right? I personally would not advise the client that it's the same if I couldn't read it. So if it ever happens that it takes away jobs from attorneys, it's like a really long ways away, like long, I'm guessing decades away from that. But yeah, there definitely is pushback in that regard. But you see companies like eSign and like the banks, for example, trying to get on board early to prevent that exact thing, right? Because they want to stay relevant. The other question here is, what's the best way to prepare to be fluent in the space? It's a good question. And the answer is, I don't know. There's a lot out there to read and sort of keep up on. It's hard even, it's hard for me to read and keep up on stuff and do my job, right? But I'd start by reading. There's tons of material available. I'm happy to offer like a resource list of like the ones I think are the best. Maybe provide it to you, Eric, for distribution. But I would start by reading. And then this is going to sound trite, but it's not. Crypto Twitter is a thing. And if you follow the right folks on Twitter, your algorithm will start feeding you the relevant updates in the space. So because developers are sort of grassroots governed, a lot of it happens through Reddit and Twitter, and a lot of the communication, like real-time communication and real-time blockchain developments happen publicly via Reddit and Twitter and GitHub. And if you monitor those forums, you can stay pretty up to date in the space. But I'm also happy just to offer a reading list. You could also take the blockchain law and policy class. That's another way.
Sounds good. And we're so glad to have you here. And thank you so much for covering this cutting edge topic. We look forward to hearing more about your experience here at Dedman Law, and also many of the topics. And hopefully we'll have you back as a hosted by the Rolling Center. So thanks so much, Professor Reyes.
Thanks for having me. And I'm sorry to talk for so long.
That was
Thanks for having
perfect.
me.
It's a good primer. So for those of you that may not have been on at the first of the presentation, I just wanted to reiterate a couple of our housekeeping items. First of all, I want to thank you for participating in our series this summer. And the materials will be available through through the Box account. So we'll distribute that and you'll be able to access all 15 lectures as well as the kind of special additional lecture with Tom Luce, our alum. Also wanted to mention that we will be having a number of other business law leadership engagements throughout the semester. These will all be online for reasons of COVID-19, but I think you can expect the same high quality and engagement that we've had over the summer. So encourage you to look out for information on that. You can go to the Rolling Center website. We'll have registration opportunities for you there. Also encourage you to follow us on Twitter as well as LinkedIn, and you can find information there. I also wanted to just give a shout out to Floy in particular. She and her teammate Jean Casagrande have made it to the finals of the LawMeet 2020 M&A Boot Camp. And this is a huge accomplishment for the team, but also for SMU. There were only 20 students from 8 law schools that were selected for the finals. And that's after an initial number of 248 students from 48 law schools who provided teams. So we wish them well. Hopefully they make it as far as they can, but we wanted to congratulate Floy and Jean, and hopefully you can wish them well. I want to mention that they're part of 6 teams that we sponsored as part of the Rolling Center. So also wish to congratulate the other 5 teams too. So if you get a chance to give a shout out, I encourage you to do so. Thank you so much, and look forward to seeing those of you that are at the law school here back on campus, or at least virtually on campus shortly. So take care and be well. Thanks.